Good morning and welcome. My name is Dr. Asif Ilyas, and I serve as the current president of the Pennsylvania Orthopedic Society. Today, Pennsylvania's orthopedic community calls upon the state Supreme Court to stop the madness. The court's Civil Procedural Rules Committee has published a proposed venue rule change that will plunge the Commonwealth back into the medical liability crisis we had endured some 20 years ago. We must sadly ask, do they not remember that crisis? Do they not care? We don't know why they are pursuing this change, but we know that a return to trial lawyer-friendly venue shopping will cause medical liability insurance premiums to skyrocket again and patient care to suffer. My colleagues and I remember the previous crisis in the late 1990s and early 2000s. Hospital maternity wards and OB/GYN practices closed, leaving hundreds of expectant mothers scrambling to find prenatal and obstetric services. Two large orthopedic practices notified patients that they could no longer obtain state-mandated liability insurance and therefore were unable to perform life-improving procedures. And hundreds of Pennsylvania physicians either retired early, curtailed their practices, or left the state altogether for lack of affordable liability insurance. Yes, we do remember the adverse impact of venue shopping had on patient care. Apparently, too few Supreme Court justices do as well. We also remember that the General Assembly, the Ridge, Schweiker, and Rendell administrations, and even the court itself joined together to resolve the past medical liability crisis. Democrats and Republicans alike chose patients over trial lawyers and enacted Act 13, adopted venue reform, and created the MCare abatement program. Simply put, our current common sense venue rules require that medical liability lawsuits be brought in the county where the alleged injury occurred. This obvious, reasonable, and effective solution constituted the most significant reform of that era. It stabilized the liability insurance market, retained physicians, expanded hospital services, and ensured Pennsylvanians would have the highest quality care possible. Why anyone in state government now would suddenly even contemplate reverting to the old venue shopping rule is beyond comprehension and belief. The surest answer today is for the state Supreme Court to stop its own Rules Committee from further consideration of the proposed venue change. Our justices have that authority and they should exercise it. So far, the Senate and the House are acting. The Pennsylvania Orthopedic Society fully supports Senator Lisa Baker's Senate Resolution 20, scheduled for a vote this week. This important resolution directs the Legislative Budget and Finance Committee to study the current rules and proposed rules' impact on our healthcare delivery system. Our society also supports Representative Donna Oberlander's schedule of hearings by the House Republican Policy Committee to study the proposed venue rule change. We are sure these hearings will demonstrate that returning to the venue shopping rule will adversely affect Pennsylvania's patients and healthcare providers. In addition to these actions, the Pennsylvania Orthopedic Society calls upon the General Assembly and Governor Tom Wolf to act on legislation that will enshrine in statute the practical remedy that liability suits be brought in the county of the alleged injury. To that end, our society is offering draft legislation to accomplish this sensible solution. This solution simply builds upon Act 127 of 2002, the statute that enshrined the current venue rule in law. Under the General Assembly's authority to establish court jurisdiction, this legislation will further define court jurisdiction over medical liability lawsuits. It is important to note that Act 127 of 2002 is a valid law, having already survived a constitutional challenge in 2003. Our proposal builds upon this near 20-year statute and ensures the court cannot unilaterally toss the Commonwealth back into a medical liability crisis. We encourage the General Assembly to enact this legislation before the Civil Procedural Rules Committee adopts their proposed venue rule change. Now, it is my great honor to introduce my colleague and friend, Dr. Mike Gratch from Abington outside Philadelphia, whose practice was one of those two large orthopedic practices that had to shutter in 2002 during the past medical liability crisis. Mike.
Thanks, Asif. I'm Mike Gratch. I'm an orthopedic spine surgeon, part of the Rothman Institute, and I'm very proud to practice spine surgery, part of the Rothman. Just one other quick note, it was actually 2001 that our large group at Abington Hospital found ourselves unable to get medical malpractice insurance. We called every insurance company in the state. We had not lost a lawsuit, had settled no lawsuits, and we still could not get insurance. I'm shuddered to think that we could go back to this awful situation. It's when we closed our practice because we couldn't get malpractice insurance, we closed the emergency room, we closed the hospital for orthopedic admissions, and the OBGYNs had to limit their practice. If you want this to happen throughout the state, then you have to go with this. But this is just insane in my mind. I'm an orthopedic surgeon, been practicing for a long time, and I talked to a colleague of mine who's a cardiothoracic surgeon who said if this passes, he's retiring. And I can tell you across the board, you're going to lose orthopedic surgeons, cardiac surgeons, all the high risk neurosurgeons. They're going to leave, and they're all underappreciated now. So it just doesn't make any sense. I agree with Asif, and I agree with our people here, all the orthopedic surgeons, that this cannot happen. We need your help. We need everybody's help. And it just doesn't make any sense to take a case from Potter County and bring it to Pittsburgh or bring it to Philadelphia just so the trial lawyers can find a good solution. You can't win a case in Philadelphia. You just can't. And as far as I'm concerned, the practice I have in Bucks County and Montgomery County, the lawsuits are fair, they're settled the right way, and it just can't continue. So we call on the government here, the Senate, the House, and my former good friend, Governor Tom Wolf, who's a classmate of mine. We need his help as well. So thank you very much, and I appreciate it.
Thank you, Mike. Next, I'd like to recognize Mr. Kurt Schroeder. The Pennsylvania Orthopedic Society supports the important public awareness campaign that is being conducted by the Pennsylvania Coalition for Civil Justice Reform. The coalition and its executive director, former state representative Kurt Schroeder, have gathered the medical, business, and insurance communities into a unique alliance that is driving much of the current legislative awareness of the court's venue proposal. The Pennsylvania Orthopedic Society thanks the coalition for their commitment to patient care and well-being. Mr. Schroeder?
Thank you, Doctor, and good morning. It's so good to see the leadership of the Pennsylvania Orthopedic Society and your members up here today to raise your voices against this very short-sighted and dangerous proposal that is pending before the Civil Procedural Rules Committee. As the doctor mentioned, I'm a former legislator, and I was around in 2002, back when Pennsylvania was in the grip of a medical malpractice crisis. High-risk specialists had to leave the state because not only was insurance, liability insurance, getting beyond their reach financially, but in many cases they couldn't even buy insurance in the private market. Family physicians and family practices were being squeezed out of existence. Maternity care was being closed at hospitals. It had become a real patient access issue in Pennsylvania. Patients were no longer having access to the critical care that they needed. There were a number of reasons for this crisis, but one of the very important reasons was this practice of venue shopping that you've heard about. You would have doctors, hospitals, and healthcare workers from different parts of the state sued in the city of Philadelphia or other high verdict jurisdictions in the state, but particularly Philadelphia was a problem area, regardless of whether the service and the treatment had any connection with the city of Philadelphia. So the General Assembly passed Act 13 of 2002, also known as the MCARE Act. It contained a interbranch commission on venue in which the Supreme Court appointed members, the legislature appointed members, and the governor appointed members. And that commission came up with a recommendation. Now imagine that, all three branches of government cooperating and working together to solve a problem. Unfortunately, that happens very infrequently today, but it happened and it worked back in 2002. and they made the recommendation that the Supreme Court adopt the current rule, which is that a medical malpractice case can only be brought in the locale where the cause of action arose. In other words, where the injury occurred. That rule is now under attack by a plaintiff's bar, by trial lawyers who never liked it in the first place because it cut down their contingency fees that they prey on the healthcare professionals in order to make a living. So we need, and we urge the Civil Procedural Rules Committee, this is an emergency. You cannot pass this rule, which would take us back to the conditions that existed in 2002 and helped fuel that medical malpractice crisis that we successfully, through passage of legislation and interbranch cooperation, were able to get out of. So that's what's at issue today. We need everyone to contact the Civil Procedural Rules Committee at civilrules@pacourts.us. I think that's right. So please contact the committee. Tell them not to approve this ill-begotten rule. And let's keep common sense that exists in the current law and the current rule for venue. Let's keep it in place. Thank you very much.
Thank you, Mr. Schroeder. I'd like to next introduce our House sponsor, Representative Ted Nesbitt of Mercer and Butler counties, to say a few words.
I want to thank the Orthopedic Society for being here today. I am proud to stand with the doctors on this important issue. I am proud to raise awareness for this issue right now that will be what I perceive as an impediment to my constituents receiving quality care that they've been receiving with the current situation the way it is. I do not believe we need a rules change, and I would encourage folks to reach out to to the Rules Committee, as Mr. Schroeder just indicated, to let them know that you do not want to see that happen. I am hopeful that working with our House leadership, as well as the Senate and the Governor's office and the courts, that we're able to reach some type of resolution to maintain the status quo, because I do not believe that the system's broken. I do not believe that we need this rule change. However, if we're not able to work out a compromise with the society, we are drafting legislation on personal jurisdiction, and to make sure that we continue to keep the actions in the counties where they arose. I'm proud to have worked with the association in the past on opioid legislation. I'm proud to work with them on this issue. Clearly, they see the significance of this. They took off time from work. They're traveling to Harrisburg to raise the awareness, to let people know that this will affect the quality of their health care. And I'm scared that that would hurt my constituents, so we need to figure out a way to make sure that that doesn't happen. Thank you.
I'd like to thank both Representative Ted Nesbitt as well as our other co-sponsored Representative Steve Menser for their support. At this point, we'll close the press conference. Thank you for your time.